Hare Krishna. Welcome to Tax Zero YouTube channel. This is your Rohan Pingle, practicing chartered accountant based in Mumbai, also partner in Motilal and Associates LLP, member firm of Marks Network. Welcome to the video series What Law Says. And today we are going to discuss two case laws under income tax. So today's discussion focuses on two landmark High Court rulings. One dealing with the reopening of assessment under Section 147 and 148A, and the other on the scope of exemption under Section 11, 12, and applicability of Section 13 of the Income Tax Act 1961. So these cases clarify what the critical aspects of procedural fairness, statutory interpretation, and taxpayer rights, areas of common controversy in direct tax practice nowadays. So let's dive into it. Let me allow to share my screen. Yes. So cases to be discussed today are one first case law, Balmer, Lawrie and Company Limited versus Union of India, 2026, assessment year 2019 and 20, and section 147, 148, 148A, that is jurisdiction and limits on reassessment. And second case we are going to discuss is about CIT exemption versus IILM Foundation, 2025. Relevant assessment years are 2009-10 to 2011-12, and relevant sections are section 11, 12, and 13, that is related to charitable trust exemptions and specified persons. So let's start with it. Our first case for today's discussion, Balmer, Lawrie and Company Limited versus Union of India. Let's understand facts of the case. The petitioner, a government Mini Ratna company, filed its return for assessment year 1920, declaring income, including commission income from facilitating the insurance policies to the customers. So the return was processed under section 143 subsection 1 without scrutiny. No income was held to have escaped assessment. On 30th March 2025, Revenue issued a notice under Section 148A Clause D, alleging information suggesting what? Escaped income. So various materials, including a dissemination note from a search in respect of unrelated groups, were shared. The assessor replied explaining its position and documentation. Revenue served a subsequent show cause notice and ultimately issued order under section 148A subsection 3 and notice under section 148 to reopen the assessment. So let's understand what was the issue under consideration. So can reassessment be initiated on a ground different from that indicated in the 148A show cause notice? Very important. Whether information available suggested income escaping assessment within section 147, and whether order under section 148A subsection 3 and notice under section 148 are justified or not. So let's see what are the relevant legal provisions relevant to that particular case. Section 147, that is for escape assessment, requires what? Information suggesting income escaped assessment. Section 148A, Section 148, notice for reassessment once reasons exist. And Section 148A, procedure before the issuing notice, including the show cause and reason order. These are the relevant legal provisions. Let's understand grounds of appeal. So assessee's main contentions were no jurisdiction. That is, there was no information before assessing officer that reasonably suggested income had escaped the assessment. Natural justice violated. That is, the show cause focused on some reliance transaction, but the reassessment order pivoted to another prudent insurance transaction not originally alleged. Irregular procedure. That is, further notices under section 148A subsection 1 didn't cure defects. Revenue relied on risk management strategy without specific incriminating material. So let's see what High Court observed and held. Change of track without opportunity. The show cause alleged tax escape because of transaction with Reliance. The reopening order was based on different facts. This violated what fairness and natural justice norms. Second, notice must be limited to grounds indicated. When a show cause notice invites response to specific information, reassessment cannot proceed on a different premise not put to the assessee. Very important. Value or remote material not sufficient. Discrimination note lacked what any nexus to petitioner. Mere listing without specifics doesn't constitute what information suggesting escapement. So reassessment quashed. Both the order under section 148A subsection 3 and notice under section 148 were set aside as unreasonable and beyond mandates of the statute. Let's see what principles laid down by this case. So assessing officer cannot go beyond the scope of the show cause notice when issuing a reason order under section 148A subsection 3. Escapement must be supported by what? Real specific information. Mere administrative data without nexus is insufficient. Natural justice and statutory procedure are mandatory even in revenue's quasi-judicial process. So moving further, we are moving to the case 2 for today's discussion, that is CIT exemption versus IILM foundation. Let's understand facts of the case. Respondent trust, that is IILM foundation, registered under section 12A, engaged in what? Charitable educational activities. Salary paid to chairperson. Salary paid to the chairperson Miss Malvika Rai was disallowed partially as excessive and alleged as application of income to a prohibited person under section 13. Revenue invoked section 13 subsection 1 clause C and section 13 subsection 2 clause C to deny the exemption under section 11-12. Issue traveled via CIT appeals and ITAT ultimately to Delhi High Court under section 260A. Let's see what were the issues under consideration. Does payment of salary to a specified person under section 13 subsection 3 automatically disqualify trust exemption under section 11 or 12? That is the first issue under consideration. Whether salary paid was excessive or unreasonable in terms of section 13 subsection 2 clause C, and if exemption denial is warranted, whether the entire income should be taxed. Very interesting. Let's see what are the relevant legal provisions. Section 11 and 12, that is exemptions for charitable institutions. Section 13, subsection 1, clause C, exemption denied if income applied for the benefit of the prohibited person. And section 13, subsection 2, clause C, excess remuneration treated as benefit to specified person. Let's see grounds of appeal. First, revenues contentions. What were the revenues contentions? Any salary or payment to a specified person automatically qualifies as application of income and thus disqualifies trust exemption. Trust payment to chairperson was inherently violative and therefore exemption were wrongly allowed. What were the assessee's contentions? Salary paid was reasonable and comparable to the service provided. Section 13, subsection 2, clause C applies only where payment is in excess of what is reasonable. Very interesting case law. So let's see what High Court observed and held. No automatic disqualification. Mere payment to a prohibited person doesn't ipso facto attract section 13, subsection 1, clause C. It must be shown that the payment is in excess of what is reasonable. Reasonableness must be assessed. Chairperson's remuneration was commensurate with the services and experience in the industry. Evidence supported service contribution. So application of income, under application of income, only the excess portion would fall foul of section 13. A reasonable salary doesn't amount to disqualifying application. So revenues appeal dismissed. The High Court upheld the IT-80's approach and held trust retains the exemption under Section 11 and 12. Let's see what were the principles laid down by this case. Section 13, subsection 2, clause C is a protective provision to distinguish unreasonable payment from legitimate remuneration. Exemption under section 11(12) cannot be denied merely because a specified person is paid unless payment exceeds reasonable quantum. Determination of reasonableness is a fact intensive and must be based on evidence and service rendered. So, what are the practical implications for tax professionals? From the case one, that is Balmer Lawrie, ensure that the show cause notice under section 148A subsection 1 are followed strictly. Revenue can't change the grounds midstream. As advisors, emphasize early and clear reply to section 148A notices to prevent the jurisdictional pitfalls. And from IILM Foundation, maintain the documented reasonableness support, that is qualification rule, comparable remuneration when related party payments occur. Understand that mere payments to specified persons aren't fatal to exemption if supported by what services. So concluding now, both rulings reinforce what the rule of law in direct tax, procedural fairness, and substantive analysis of statutory criteria. Balmer Lawrie curtails revenue's ability to arbitrarily reopen the assessments without solid and specific information, whereas IILM Foundation provides clarity on charitable exemption, especially regarding payment to specified persons, offering relief to genuine institutions. These principles significantly impact litigation and compliance strategy for taxpayers and advisors alike. So that's it for today. Thank you. Thank you so much for patient hearing. If you want, you can note down my contact numbers. And if you want to suggest anything, observation, queries, any questions, then do let me know via WhatsApp, email, or you can also comment below the video. So thank you. Thank you so much once again. If you are not yet subscribed to Taxwell YouTube channel, then do subscribe for latest updates and video series like this. Thank you. Thank you so much. Bye bye. Take care. See you soon. Hare Krishna.